The next case to come before the court is NJA and RP. You're going to argue this with her?
Yes, Your Honor.
You'll have 15 minutes to present your argument. You can reserve up to 5 minutes for rebuttal. Just let me know how much time you wish to reserve, and I'll do my best to keep track for you. Do not use the names of any children in this case. I think you well know. And we've read your briefs, and we're ready to begin whenever you will.
Thank you, Your Honor. Your Honor, good afternoon, good morning. I would like to reserve 5 minutes for rebuttal. Good morning, Your Honors. Andrea Whitaker on behalf of the appellant mother in this matter. I'm going to focus today on our assignments of error 1 and 2 that may touch, of course, upon the third and fourth assignment, but that's where I would like to spend my time. I'd like to start by asking the question that Summit County Children's Services needed to prove at the adjudication in this matter, and that is if they could prove by clear and convincing evidence that this young child was abused, injured after she left the hospital and in the care of her mother. That is the issue that Summit County Children's Services was required to prove by clear and convincing evidence at this adjudication. And as the court knows from reading our briefs, we have a very tight time frame here. The child was born in September, was released from the NICU on November 23rd, and then presented to Akron Children's Hospital on January 9th. There's no testimony whatsoever that the injuries could have occurred during the 3 weeks prior to Akron Children's Hospital. So we have a brief period of time between the NICU release on November 23rd and December 18th, which is 3 weeks prior to Akron Children's Hospital, that Children's Services alleged an abuse occurred. During that time frame, of course, the child was taken to 2 separate pediatrics visits. I'd like to start, after addressing that type time frame, with why Dr. McPherson's changing both narrative and dates for his diagnosis matters, because we have both the magistrate and the trial court indicating in their opinions that it does not matter. And it does. It matters, number one, because these are significant differences. Dr. McPherson went from 3 to 5 days to at least 7 to 10 days to at least 21 days old for these injuries. He also made a significant change from his initial medical diagnosis that he believed and stated in his report that the rib fracture and subdural hematomas may have occurred at the same time. Of course, he testified at the adjudication that there's no evidence to support that statement. So why does this shifting time frame, why does this narrative matter? It matters because the incorrect time frame does not allow for a consideration of precluding of injuries that occurred prior to that time frame. Other events, other parts of this young child's life that should have been considered for potentially when these injuries occurred. And again, as I indicated, we are dealing with such a tight time frame here that has a significant impact on Dr. McPherson's ability to rule out other causes of these 2 injuries. And Dr. McPherson himself testified that ruling out other potential causes for these injuries is what is essential to do if he's going to arrive at a diagnosis of abuse. So the time frame, I would respectfully disagree with the trial court and the magistrate, is very important here for Dr. McPherson's own position about having to rule out other causes. Now, Appelli argues that it's okay that he didn't rule out other causes necessarily initially, that he later went and looked at some prior medical records, and he still feels the same way. I think it's important to note that it's a whole different ball of wax to rule out other causes when you are looking at the initial diagnosis, as opposed to 6 months later, looking solely at the discharge statement after the children have been separated from their mother by 14 months total. At that point, it had been 6 months. After the mother had been criminally charged and after the abuse the abuse complaint had been filed. I think it's also important when you look at why his shifting narrative and time frame matters, because Dr. McPherson himself, in the abuse transcripts, refuses to admit even that his time frame changed. He says again and again, I never changed my time frame. No, it's okay. I said at least 5 to 7. That's the same thing as saying at least 21. I never changed my testimony. I never changed my opinion. And I think that that's significant in terms of the fact that what appellee wants to tell this court is, again, Dr. McPherson went back 6 months later and was able to, with a fresh look at the records, look at all the records from Cape Fear and make a determination that his initial diagnosis was correct. He's even unwilling to make the slight give or acknowledge that even his time frame has changed. So I think that's important when this court looks at why that time frame is important, and I think it's important when the court looks at the information relied upon for Dr. McPherson's initial diagnosis. Dr. McPherson never actually reviewed the radiology records. Again, Dr. McPherson told the court it was important to rule out other causes. He never reviewed the radiology records. In fact, only mother's experts ever looked at the actual images from Cape Fear Hospital. Dr. Ganapathy looked at the x-ray of the baby's torso on the stand, but Dr. McPherson never looked at any radiology records from Cape Fear. So the fact that there was a potential rib fracture in October of 17, while the baby was at the NICU, was never ruled out. Dr. McPherson never looked at that radiology record. And both Dr. Sullivan and Dr. Ganapathy, if the court will recall, is Akron Children's Hospital's chief pediatric radiologist, not called by Children's Services, in fact objected to by Children's Services, but he testified, consistent with Dr. Sullivan, that the lucency we see on the October x-ray is at the exact same location as the rib fracture appreciated at Akron Children's Hospital. Never ruled out by Dr. McPherson because he never saw those images. The other thing that Dr. McPherson did not consider, did not rule out when it comes to the bone fracture, the rib fracture, is the evidence that was in existence in January of 2018 of the fact that this child's bones had previously been under-mineralized. Now that was evidence that the court heard from both Dr. Sullivan and mother's expert, and again, Dr. Ganapathy, Akron Children's Hospital's radiologist. The images of the child's skull showed craniotopes. That is evidence of prior under-mineralization. And there was no consideration for that given by Dr. McPherson when he made his diagnosis. And that is important for two reasons. Number one, that evidence of prior mineralization, under-mineralization, shows us that the bones would have been healing at a slower rate. Again, we're back to those time frames. That is an important consideration when the doctors are looking at the time frame for these fractures. So it's an important consideration for that fact, the baby's condition during this time period, and how the baby would have reacted to the trauma of birth and the trauma of 6 weeks in the NICU with invasive respiratory therapy. So let's talk about what the evidence demonstrates, even from Dr. McPherson's position, regarding the time frame of these injuries potentially. Dr. McPherson, for the first time on the stand, acknowledges that the rib fracture was at least 3 years old, and there's cites to these in our brief, and I certainly can provide them to the court if the court requires. He indicates that the rib...
Before you go on, you said 3 weeks, right?
He said that it is at least 3 weeks old.
I thought you said years, that's why.
No, I apologize. That had been impressive.
Yeah, that I was gonna say.
He
I
says
just
that,
wanted to make sure, it's clear.
I appreciate that, Your Honor. He also indicated that the rib fracture, if the rib fracture had occurred at the NICU, then 1918 Akron Children's Hospital x-ray could have looked the same as it did the day that she was at Akron Children's Hospital. He agreed in his testimony that the subdural hematoma could be months old. He agreed that the subacute to chronic subdural hematoma can be 2 weeks to 2 months. He acknowledged the possibility that the subdural hematoma occurred while she was at the NICU. He agreed again that it was possible that the rib fracture occurred at the NICU. And he agreed that the subdural, again, could have been, began before she was discharged, and he acknowledged that the rib fracture was diagnosed at Altman Hospital as healing or healed. So these are all statements by Dr. McPherson. Dr. McPherson, who says again and again that he must rule out other causes. His testimony continually talks about the possibility.
You can continue, I just want you to know you're in your rebuttal time.
I appreciate that, Your Honor. I will just touch on very briefly the other things while I think it's important for this board to consider both sufficiency and weight. Dr. McPherson's own medical records indicate that he could not identify whether the subdural hematoma was from accidental, whether it's from trauma, inflicted trauma, or the benign enlarged subarachnoid space. Dr. Ganapathy testified that a baby with the skull of this young child has an increased propensity for subdural hematomas. And Dr. Ganapathy said in all his years of practice, he has never seen a rib fracture as a result of abuse. He's never seen it in the x-rays. And of course, there's the lucency that we see on the October x-ray that was not considered or ruled out by Dr. McPherson. I think that those factors, coupled with Dr. McPherson's inability to testify that he believes to a reasonable degree of medical probability that it was abuse, that he was only able to say that it is consistent with abuse, demonstrates that there was not sufficient evidence and that the weight of the evidence was not that there was clear and convincing evidence of abuse.
Thank you.
Good morning, Your Honors. May it please the court, counsel. I'm Jacqueline Corbin on behalf of Summit County Children's Services, or otherwise known as the agency. I'd like to start off, first of all, with sort of a housekeeping matter. I discovered that there was an error in the agency's brief regarding assignment of error 4. There are actually 2 citations that should have been called to the court's attention. It was a typographical error not to include the second one. Regarding the UCCJEA, section 3127.18 describes when an agency can have emergency temporary custody of a child in Ohio. It's actually 3127.15 that talks about when the child is in their home state.
What page are you on?
I am under assignment of error number 4.
Assignment error 4.
Yes, ma'am. And that's regarding whether there was jurisdiction here in Ohio to hear this case. There's also 2151-23A8, I believe I cited that one correctly. But also, in light of all of this, or considering all of this, there's the recently decided case from the Ohio Supreme Court from October of 2019 of CH versus O'Malley that talks about the impact of the UCCJEA on a case such as this one that has been filed, dismissed, refiled multiple times. So I would just want to call the court's attention to that, correct my error, and I apologize for that. Now, getting to Mother's specific arguments here today, she didn't actually phrase her assignments of error in terms of sufficiency, but in terms of manifest weight, as I believe. But in either case, the standard that the trial court, the magistrate who was hearing this case had to apply was whether the evidence was clear and convincing, not whether it was proof beyond a reasonable doubt, which seems to be where Mother is going with this. But I would also like to remind the court of the fact that the magistrate's decision was then reviewed independently by the trial court in this case, as the court can see in the trial court's order where the trial court cited to portions of the record with specific transcript pages and actually reached reached the same legal conclusions but for slightly different reasons than did the magistrate. So this decision was already independently reviewed. And as a consequence of that, as we well know from review of these cases, this court then applies an abuse of discretion standard of review to decisions such as this. And Mother basically has claimed that the trial court abused its discretion in 4 ways, but it did not. And to get to that point, I want to remind this court of what an abuse of discretion actually means. Now, what that means is that this court cannot, when this is the standard of review, this court cannot merely make a different decision than the trial court and substitute its judgment for the trial court. Instead, this court would have to find that the trial court's decision below was unreasonable, arbitrary, or unconscionable. And we frequently have that standard, discussed. But what that actually means is that the trial court's decision has to be unjust or unfair, has to be palpably and grossly violative of facts and logic, and it has to demonstrate that the trial court had an improper basis for reaching the decision that it did, such as there's 4 P's, and I apologize for the alliteration: passion, prejudice, partiality, perversity of will, and moral delinquency. So unless this court finds that that's the case, then this court cannot merely substitute its judgment for that of the trial court. Now, an abuse of discretion does not mean mere error, and it also does not mean a mere disagreement by any of the parties as to the conclusion that the trial court reached. And Your Honors, that seems to be what we have here with Mother's case, is that she, in attacking Dr. McPherson, she vehemently disagrees with the trial court's decision to rely in any way, shape, or form upon Dr. McPherson's testimony. Just very briefly, I would remind the court of a couple things. First of all, Dr. McPherson wasn't simply a hired gun who was hired after the fact, and I'm not saying that anybody's expert in this case was a hired gun, but he wasn't one of those experts that comes in and looks at documents after the fact and never has treated the patient. Dr. McPherson was one of the team of doctors at Akron Children's Hospital who actually evaluated this child. And I'm focusing on the younger child, the daughter, RP. I would also talk just briefly about Mother's contentions about the time frames of these injuries. Now, RP suffered essentially 2 categories of injuries. First, there was a rib fracture. And even though Mother challenges the timeline of that, Dr. McPherson eventually said that the rib fracture was at least 14 to 21 days old. But there was also a series of subdural hematomas that were described as being differentiated in that child's skull. Dr. Ganapathy, upon whom Mother relies heavily, had testified that those subdural hematomas, and by the way, the subdural hematomas was the only area upon which the trial court was willing, because of the procedural posture of trying to get Dr. Ganapathy to be able to opine as to rib fractures when he was reading films that weren't his, or weren't taken by Akron Children's Hospital. Dr. Ganapathy was still qualified to testify concerning subdural hematomas, and testified that the subdural hematomas that this child suffered could have occurred as little as 2 to 3 weeks prior to her MRI at Akron Children's Hospital, and as much as 2 months prior to that. And I can refer the court to specific pages in the record for that testimony. Take a look at pages 718 to 719 and 736. That time frame puts that child out of the NICU in North Carolina and certainly beyond the point of birth, because there were two things that mother had been arguing through this case was it could have been a birth injury because of this extremely difficult foot-length breech C-section, or it could have occurred in the NICU. That time frame puts that out of that. And again, I would remind the court, the agency did not have to prove beyond a reasonable doubt that mother committed any kind of act that caused this subdural hematomas. So, but I would just like to be able to demonstrate to the court that there was some reliable probative evidence upon which the trial court in this case made its decision. But again, getting back to abuses of discretion, trial court decisions to believe or to weigh one party's evidence or their witnesses, including expert witnesses, does not constitute an abuse of discretion. And I can cite this court to at least 4 cases that have been decided on that specific issue. There is no case law supporting mother's contention in her reply brief that experts are to be evaluated for admissibility or weight by a different standard than any other witness. And as far as the cases that mother cites in her reply brief that say that one must exclude the testimony of an expert for lack of certainty as to their opinions, mother cites to State versus Holt, that's from 1969. That's not only pre-Daubert, but that also was issued before the rules of evidence were enacted in Ohio. And it was also questioned further by the Ohio Supreme Court in State versus Glenn Benner, and I can give you the citation of that. It's 40 Ohio State 3rd 301 at page 313. And then as far as Shoemaker versus Oliver Buchanan, that was decided in 1986. Again, that was a pre-Daubert versus Merrill Dow Pharmaceuticals case, but it was also abrogated by State versus D'Ambrosio, 67 Ohio State 3rd 185 from 1983, which is slightly post-Daubert. And in the D'Ambrosio case, the Ohio Supreme Court abandoned the notion that one had to testify in terms of probabilities and said that possibilities was an acceptable standard for admission of expert testimony where proximate cause is not at issue. And mother has admitted in her reply brief that proximate cause is not at issue in this case. Therefore, this was not an admissibility issue. This is concerning weight of the evidence, not admissibility. And that gets further into the realm of an abuse of discretion standard that needs to be applied to the trial court. Now, unless the court has any further questions for me, I believe we've covered the rest of everything else pretty thoroughly in our briefs, and the agent, okay, I saw that look of consternation, Your Honor, that thought maybe you had a question, but otherwise the agency would rely on its briefs and urge you to affirm. Thank you very much.
All right, thank you.
Thank you, Your Honors. I'd like to begin by first obviously pointing out that our assignment of error number 2 deals with sufficiency. So 1 and 2 are weight and sufficiency of the evidence here. In terms of one of Appellee's concluding arguments, that the case law predates Daubert and predates some other case updates. What our brief said is that the case law has evolved and cited a case where it talks about that it's still admissible. But of course, saying that something could have been the cause is not enough. It is not enough to establish that by clear and convincing evidence. It's really not enough to establish it by more probable than not. But it's certainly not enough to establish it by clear and convincing evidence. And that's why this is not just a simple disagreement with how the court weighed the evidence. there was not evidence upon which this court could have relied indicating that these injuries were abuse. All we heard from Dr. McPherson was that it's consistent with abuse, that these could have been 2 to 3 weeks or 2 months. I will cite to Dr. Ganapathy's testimony, only part of it was quoted by Appellee, which he said it was 2 months. What he said is, well, it could be 2 months, could be 3, because the baby's not older than 3, so it can't be any older than that. So Dr. Ganapathy absolutely testified that this subdural hematoma could have occurred while the baby was in the NICU. I would also like to just touch briefly on Dr. Ganapathy's testimony and the limitation that was discussed in our assignment of error and addressed by Appellee. Dr. Ganapathy was limited from testifying about anything other than the radiological images of the subdural hematoma, despite the fact that he testified frequently, I know it's hard to see that on the transcript, with some vehemence, that part of his care and treatment of this young baby was review of all the radiological records. That includes the rib fracture, and he specifically discussed the rib fracture x-rays as well as the head radiological images with Dr. McPherson, and told Dr. McPherson, as it relates to the subdural hematoma, that it could have been months old. He told that to Dr. McPherson before he wrote his report. He discussed the x-ray of the rib with Dr. McPherson, and so there was no proper limitation of Dr. Ganapathy's testimony here. I would also like to point out in response that I believe I misspoke when I said Dr. Ganapathy said he'd never seen a rib fracture. It's a single rib fracture, just one rib fracture be diagnosed as abuse. That's what his testimony was, and Dr. McPherson agreed with that.
Made me wonder.
Yes, and I apologize for that. Mr. Whitaker caught that. What he testified was that in all his years of practice, he'd never seen a single rib fracture be diagnosed as abusive. I think that Appellee discussed the abuse of discretion, and while obviously that is...
You're over.
Okay.
Go ahead and just finish this up.
Okay, what we've said here is that the doctor's testimony, that it's consistent with, and not that it is in fact abuse, is not sufficient evidence. It is not clear and convincing evidence, and certainly this court knows that it can look at the evidence and determine that clear and convincing evidence was not presented. Thank you.
I have a question for you
Yes, Your Honor.
regarding, I want to get the name right, I can't pronounce it, the radiologist.
Dr. Ganapathy, yes.
Thank you. Well, there's been a lot of reference to his testimony.
Yes.
Am I confusing this case? I don't think I am because of your third assignment of error. His testimony was excluded, but you proffered, is that correct?
Your Honor, the way procedurally the magistrate did it, which was an unusual experience for me, is initially she said it would be proffered, and we have these sites in our brief, then she said she would allow him to testify, but only about his actual treatment, which is when she said he couldn't talk about the x-rays. And then when she allowed him to discuss the rib fracture, she then indicated that would be a proffer, and she left the stand. And so that's what's indicated in the transcript, that she actually left the courtroom when he testified about the rib fracture.
Since she was the finder of that.
Yes, so she left the courtroom, and that became the only portion that was a proffer, just the part about the rib fracture.
All right, thank you both for your arguments. We will take this matter under advisement, issue a written decision in due course, and will be mailed to both sides as